Well, later today, a landmark civil rights case is set to be argued before the Supreme Court.
The U.S. Supreme Court has just issued a major ruling in the challenge to a New York gun law.
Major Supreme Court ruling.
Most significant case regarding the Second Amendment in more than a decade.
The Supreme Court will be taking up a gun rights case.
Members of the Senate are focusing on gun rights in the wake of the Supreme Court's Bruen decision.
Major ruling involving the Second Amendment.
Major Second Amendment case.
Major Supreme Court ruling.
It's a case that legal experts will be watching closely.
Breaking news from the State House. One of the big bills in front of the Senate, the assault weapons ban, just passed.
20 to 30 million AR-15 rifles currently sit in American homes. That's more than the number of Ford F-150 trucks on the road. For decades, these rifles have been legally purchased, legally owned, and legally used for everything from home defense to competitive shooting to hunting. Yet right now, 9 Supreme Court justices are considering whether local governments can make owning one a criminal offense. This isn't a theoretical debate about future legislation. Cook County, Illinois has already made it a crime to own, sell, or transfer over 100 specific rifle models, including every AR-15 variant and AK-47 platform. The penalties are real, the enforcement is active, and a federal appeals court has upheld the ban as constitutional. The case is called Bevis versus Cook County, and it represents the last line of legal defense for the most commonly owned rifle in America. The plaintiffs lost in district court. They lost in the 7th Circuit Court of Appeals. Now their final hope rests with the Supreme Court, which hasn't yet decided whether to even hear the case. What happens next could either protect Second Amendment rights for generations or create a precedent allowing every county and city in America to implement their own patchwork of firearms bans. The stakes couldn't be higher, and the legal arguments reveal contradictions that go straight to the heart of what the Second Amendment actually protects. Cook County's ordinance doesn't just ban AR-15s by name. It prohibits any semi-automatic centerfire rifle with features like a pistol grip, folding stock, or even a muzzle brake. The definition is broad enough to capture dozens of popular hunting and sporting rifles that have nothing to do with military applications. Individual citizens backed by the Second Amendment Foundation filed the lawsuit arguing this ordinance violates constitutional rights explicitly protected by the Second Amendment. District court judges disagreed. The 7th Circuit Court of Appeals disagreed. Both courts ruled that despite the Supreme Court's previous decisions in Heller and Bruen establishing individual gun rights, local governments can still ban entire categories of firearms. This creates urgent questions. If the most commonly owned rifle in America doesn't receive Second Amendment protection, what does? If 20 to 30 million rifles in civilian hands don't qualify as in common use, what would? And if local governments can ban popular rifles, can they ban popular handguns next?
The right to keep and bear arms shall not be infringed.
Justice's ruling this morning, it conflicts with the Second Amendment's right to bear arms.
And today the Supreme Court said that's unconstitutional. That puts a limit on the right to have a gun.
My response to that is that's the same claptrap that they have been using for 20 years.
You couldn't get a firearm and carry it just because you wanted to be protected against criminals. We won't see changes overnight, but it's going to be quick.
Everybody has a right if they're a responsible adult.
This case could reshape how far states can restrict your right to carry and wear.
What makes this case different from previous attempts to get Supreme Court review is strategic timing tied to a specific justice's public statement. Last year, the Supreme Court denied review of a rifle ban case called Snope versus Brown. Gun rights advocates were devastated. The denial seemed to signal the court had no interest in addressing so-called assault weapon bans. But Justice Brett Kavanaugh wrote something in his statement denying that case that changed the calculation entirely. He explicitly stated that the Supreme Court would need to address assault weapon bans within the next term or two. This wasn't vague judicial language. It was a timeline, essentially a promise that this issue would receive attention soon. The plaintiffs in Bevis versus Cook County have structured their entire petition around Kavanaugh's words. Their legal brief essentially argues, "You told us this issue would be reviewed soon." Well, it's been a term. Here's your case. Legal experts say this strategic approach is unprecedented because it directly challenges a Supreme Court justice to either keep his public commitment or be seen as backing down. What's more significant is that Kavanaugh's statement wasn't just personal opinion. It signaled that at least some justices on the court believe this issue requires urgent clarification. The timing of this petition couldn't be more calculated, and that's exactly why this case has realistic prospects of being heard when so many others have been rejected. The constitutional chaos becomes even clearer when you examine how different federal circuits are applying Supreme Court precedent. Some circuit courts acknowledge that AR-15s qualify as arms under the Second Amendment, but still conclude states can ban them anyway. Other circuits claim AR-15s aren't protected arms at all because they're supposedly too similar to military weapons. The Seventh Circuit, which covers Illinois, ruled that any firearm useful in military service can be banned by state or local governments. Think about the implications of that standard for a moment. The entire original purpose of the Second Amendment was ensuring citizens could possess weapons useful for militia service, which by definition means military utility. The Fourth Circuit upheld Maryland's assault weapon ban using different reasoning. The First Circuit did the same for Massachusetts with yet another legal framework. Meanwhile, other circuits haven't ruled on similar challenges, creating a patchwork of conflicting interpretations across the country. This means your constitutional rights literally depend on which state you live in. What's perfectly legal in Texas could result in criminal charges in Illinois. What you can lawfully own in Arizona might get you arrested in New Jersey. This is exactly the kind of constitutional chaos the Supreme Court traditionally steps in to resolve. The court has historically granted review specifically to resolve circuit splits, situations where different appeals courts reach contradictory conclusions on the same legal question. And this split is about as clear as they come. Gun owners are effectively living under different constitutions depending on their zip code, which fundamentally contradicts how constitutional rights are supposed to work. The petition filed with the Supreme Court includes data that's difficult to dismiss. Production numbers show AR-15s consistently rank as the best-selling rifle platform in America year after year. Surveys demonstrate these rifles are used for lawful purposes including home defense, competitive shooting, hunting, and recreational target practice. The plaintiffs argue that if the most commonly owned rifle in America doesn't qualify for Second Amendment protection, then the phrase, "the right to keep and bear arms," becomes meaningless. It's not just gun rights advocates making this argument. Legal scholars across the political spectrum acknowledge the tension. Cook County's response claims these rifles are dangerous and unusual. But how can something be unusual when tens of millions of Americans own one? AR-15 ownership has grown by over 400% in the last 2 decades, making it the single most popular rifle platform in American history. To put this in perspective, more Americans own AR-15s than own Jeep Wranglers. Nobody's calling Jeeps unusual. The common use standard the Supreme Court established in Heller seems impossible to meet if 20 to 30 million units don't qualify. The county also argues that AR-15s are too similar to military M16 rifles, which creates a logical trap the government can't escape. They're claiming AR-15 should be banned precisely because they resemble military weapons, but the Supreme Court's 1939 ruling in United States v. Miller established that the Second Amendment protects weapons with military utility, specifically weapons that could be used by a militia. So which is it? If AR-15s are militaristic, they're exactly the type of weapon the Second Amendment was designed to protect according to Miller. If they're not militaristic, then the government's entire argument collapses. The Seventh Circuit attempted to resolve this paradox by claiming that weapons most useful in military service can be banned, which directly contradicts Miller's holding. The plaintiffs are hammering this contradiction repeatedly in their briefs. They're essentially arguing you can't have it both ways. Either these are military-style weapons protected by the Constitution, or they're civilian sporting rifles that pose no unique danger. Even more problematic for the government's position is that AR-15s have been in civilian hands since the 1960s, decades before the military widely adopted them. This undermines claims that they're primarily weapons of war. The functional differences between AR-15s and military M16s are also significant. The M16 has select fire capability, allowing fully automatic fire. The AR-15 is semi-automatic only, the same firing mechanism found in most modern handguns and hunting rifles. One trigger pull, one bullet. That's the legal standard that's existed for nearly a century. This military weapon paradox represents one of the strongest arguments for Supreme Court review because lower courts have created a constitutional contradiction that only the highest court can resolve. Facing weak arguments on constitutional merits, Cook County has thrown up every procedural roadblock available. They claim the plaintiffs rushed the case to the Supreme Court without completing proper discovery in lower courts. They argue insufficient factual evidence was presented to prove AR-15s are commonly used for lawful purposes, despite the petition including surveys, production data, and sales figures showing tens of millions in circulation. They also claim there's no circuit split despite obvious contradictions between how different appeals courts interpret Heller and Bruen. Legal analysts recognize these arguments for what they are: desperate attempts to avoid a ruling on the actual constitutional question. When government entities accused of violating rights start arguing procedural technicalities instead of defending their law's substance, it usually indicates they know they'll lose on merits. The county even admits in their response brief that every circuit court has upheld assault weapon bans, which accidentally proves the plaintiff's point. There is consensus among lower courts, and that consensus may be constitutionally wrong. That's precisely why Supreme Court intervention is needed. What's particularly telling is that Cook County spent more pages arguing about procedures than actually defending why their ban is constitutional. Their entire strategy appears focused on avoiding the core question rather than answering it, suggesting they understand exactly how vulnerable their position is. The real question now is whether the justices will engage with these procedural distractions or cut through them to address the core constitutional issue affecting millions of gun owners nationwide. 4 justices must vote to grant review for the case to proceed. Given the circuit split, the number of rifles at stake, and Justice Kavanaugh's previous statement, the prospects are stronger than they've been for any similar case in years. This case will determine whether Second Amendment rights have meaningful content or can be legislated away one rifle category at a time by local ordinances. It will establish whether common use means something concrete or can be defined away by governments that disapprove of certain firearms. And it will clarify whether the military utility that motivated the Second Amendment's drafting now justifies banning the very weapons that possess such utility. The Supreme Court's decision on whether to even hear this case will signal how seriously the justices take their own precedents, and whether constitutional rights truly apply equally across all 50 states. The answer will shape firearms law and Second Amendment jurisprudence for decades. That's it for today, folks. See you in the next video.